Hello, and welcome to Family Law History 101. Today's lesson will focus on language manipulation. Proponents of Senate Bill 174 have hyped its modernized language.
Senate Bill 174 will create a child-centered approach and eliminates terms such as a residential parent and custodial parent to remove the perception that one parent has more power or authority than the other parent. This was a deliberate decision to help minimize the adversarial nature of this type of proceeding.
How likely is it that these changes will achieve the stated effect? To answer that question, let's revisit the 1987 report of the Domestic Relations Task Force. After finding widespread dissatisfaction and disillusionment with the law, the task force recommended that certain words be replaced with more appropriate words, seeking to acknowledge that children are not property. By the way, children as property is a manipulative and disingenuous position to take. Family law insiders make this argument hoping you'll recoil at the thought of treating people as property, then be too stupid to dispassionately consider the reality of the situation. That is, the child's time must be divided. Marital property is either given to one of the parties or sold, with the proceeds divided between the parties. You don't split the house, allowing one parent to live there every other weekend. So clearly, children are treated differently. Starting at 50-50 does not translate to treating children as property. It's current law that creates assets of the children for those that prey on its adversarial nature. Inciting parents to fight over the child means more revenue for the experts making the children as property claim. In 1991, the legislature followed through on those recommendations, overhauling family law. A state policy stressing the importance of both parents was added in 1998, and the language was updated again in 2001. What impact did this enlightenment have on Ohio's adversarial parent sidelining culture? Well, the 2023 Child Support Guidelines Review revealed that only 1 in 6 parenting time orders provided at least 90 overnights for each parent. Why is that significant? Because, over 20 years prior, the Task Force on Family Law and Children recognized that such a disproportionate split drove the adversarial nature of the proceedings. So, even though the words changed on paper, in practice, courts continued to implement wildly disproportionate parenting time schedules, thereby perpetuating the adversarial win-lose culture of family court. Enter Senate Bill 174 and its recycled solution of more superficial wordplay, targeting the very words the experts championed decades ago. Seeking to rehab the perception of family law, rather than reform the reality, proponents hope that parents will be too stupid to notice they're being marginalized. We've been down this road before. Softening the language of the law did not result in a change to the lopsided outcomes of custody cases, but an entrenchment of the parent sidelining culture that already existed. There is no reason to believe that this round of language manipulation will be any different.